Yes, good evening, everyone. So, today we'll be going to take a look at the topic conflicts between the PMLA and the IBC, and we'll be exploring all the jurisdictional overlap that has been there since the enactment of the IBC with the PMLA, and what all issues have identified by the tribunals adjudicating authority under the PMLA as well as the high courts and Supreme Court. So we'll start with today's lecture. So, firstly, just to give a brief overview of the two legislations, I know you all have studied IBC in depth by now, and you have a good idea that what is IBC all about. And it is basically a law which has been created to simplify and to fast track the resolution proceedings to resolve the insolvent entities in a better manner. And on the other hand, when we talk about the Prevention of Money Laundering Act of 2002, so this act interestingly was enacted in the year 2002, and it came in force in the year 2005 only. So it took almost about 3 years for the government of India to enforce the provisions of this act. And this particular legislation was enacted with the view to tackle the financial crimes uh, like money laundering. And so, to tackle that particular problem, this act was enacted. And the usual conflict between the provisions of IBC and the PMLA comes when an insolvent company is also, under the comes under the ambit of PMLA as well. Or in other words, if a company is found, of is there when there are allegations against a company of a money laundering activity, and that particular company also goes insolvent, then there comes a situation where these two legislations overlap with each other. And obviously, when two legislations are overlapping with each other, the conflicts, the issues are bound to be uh, raised up in the proceedings. So mostly when we are dealing with the PMLA and IBC, the most common question is with regard to the attachment of property. So attachment of property under the PMLA, and taking control of the property by the resolution professional under the IBC. So when that particular situation arises where a company goes insolvent as well as comes under the ambit of the PMLA legislation, so the property of the company, who should get that property? Is it the enforcement directorate, or is it the resolution professional who should take hold of the property? So when we are looking at the conflicts between IBC and PMLA, so it becomes very important that we look at the legislative objectives of these two acts. And primarily, when we talk about the Insolvency and Bankruptcy Code, so it prioritizes the revival of distressed companies, and it has been enacted with a view to protect the interest of the stakeholders, the creditors, so that the creditors can, you know. Per se, it is not a recovery legislation, but yes, it is enacted with a view that a particular corporate debtor, when it is being revived, the creditors are, they are also placed on a better footing to obtain as much as from they can from the uh, resolution applicant, and gain their something out of the debt of the so many debt which that particular financial creditor or the operational creditor is having. They are also able to gain out of those insolvency resolution proceedings. However, on the other hand, when we talk about the PMLA, so PMLA has been enacted with a view to deteriorate and punish the money laundering activities. So basically, the IBC is more of a economical legislation, whereas the PMLA is more of a criminal legislation. Now, if we talk about the national interests, so both these legislations are, in favor of national interest, because one legislation, IBC, is particularly, it is the ultimate goal which the IBC foresees is the promotion of the financial and economic sector of the country, whereas PMLA also focuses on the national interest because it is, getting hold of the biggest criminal minds of the country who are floating away with crores of money, and ultimately the effect of that, such fraud, scams, and money laundering, such activities also impacts the overall economy. So more or less the two legislations are somewhat on a, you know they are somewhat resolving the same problem but in a very different manner. So the intention of these two legislations are very different. IBC does not focuses on the punishment aspect, whereas the PMLA focuses on the punishment aspect, and PMLA does not focuses on the, looking after the interest of the creators, whereas the IBC is looking after the interest of the creators. So that's how these two legislations are, intended by the legislature, and these are their main objectives. So, where is the problem under these two legislations? So, the purpose of attachment of property under PMLA is basically, there are, as per, my experience, there may be twofold reasons. So, one is to secure the attendance of the accused. So you attach the property of the accused so that the accused who has, gone into hiding after the all the allegations has been leveled against him for money laundering. So attaching the accused property, may prevent him from fleeing the country, and you know it, because property is something that everybody needs. So you attach the property to secure the attendance of the accused, number one. Number two, you attach the properties to prevent the further activities of money laundering. So when a property is being used to further the money laundering activities, so to prevent that, you attach the properties. However, when we go under the IBC, in IBC, the assets are, given to the resolution professional. So resolution professional come forward and take control over the assets after the moratorium has been declared. So that under the IBC, the assets are very much necessary to be under the control of resolution professionals so that there the RP can initiate, there is no misuse of the assets, and the maximization of value of assets can be there. The RP is able to put forth a true picture before the committee of creditors, and also the RP is able to put forth a true picture to when he is inviting the, resolution applicants to submit their plans. So to assess the company, the whole structure of the company, and to offer a best restructuring scheme, it is very much necessary that the assets are now under the control of the RP, so that at a later point of time, when it if it is insolvency resolution proceedings or even the liquidation proceedings. So if the assets are under the control of RP, they can be liquidated and they can be better realized of their value to the benefit of the stakeholders who are the creators under IBC. So the problem with the purpose of attaching the property under PMLA and the purpose of taking control over the assets under IBC, so these two purposes clash with each other, and we have seen a lot many situations have now come up where there is a, fight going on between the enforcement directorate and the RP, when the enforcement directorate is approaching NCLT to get release the assets from the control of the RP, and vice versa, the RP is going to the adjudicating authority under PMLA Act to get the property released from the hold of ED. So there has been a legal tussle between these two laws in this manner. Now, as we have already discussed, the main issue of property. So now we also need to understand what is the ultimate goal when the property is attached under the PMLA. So ultimately, let's presume all the proceedings under PMLA are going with a very good flow. There are no disputes at all. So where does this property go? So ultimately, this property goes to the central government. It is confiscated by the enforcement directorate, and upon the approval of the adjudicating authority, it the property goes and vests into the central government, where the central government conducts further auctions. That is a totally separate thing. So basically, in simpler terms, we can understand that the property goes to the treasury of the central government. Whereas under the IBC's ultimate goal for the property, if the insolvency resolution proceedings are going on, so then the property goes to vest in the resolution applicant. And for that property, resolution applicant pays a good amount of money. So, and that money is used to pay off the debts of the creditors. So ultimately, the property under IBC is used to satisfy the debts of the creditors. Now, when we talk about the goals of the two legislation, so obviously when we are talking about IBC, there are lot many stakeholders involved as compared to PMLA. So in PMLA, usually what we have seen when there is an offense of money laundering, so usually the banks have been defrauded, and interestingly, when we come to IBC, also most of the financial creators are banks. So how do you balance these two legislations when the affected party is same, but there are two distinct proceedings going on? So is the bank benefited under the PMLA, or is the bank benefited under the IBC? See, as far as the goal of the PMLA is concerned, the PMLA and the Enforcement Directorate is more focused to, punish the accused and get hold of the property, and later on that property is confiscated and is vested in the central government. So, whereas in the IBC, the financial creditors play the main role because they get the seat in the COC, and committee of creditors takes decision for the resolution or for the liquidation of the particular company of the particular assets. So banks are somewhat better placed in the Insolvency and Bankruptcy Code as compared to the PML. So still the property custody clash is going on. So now if we take a step back and go to the BLRC report. So this particular conflict of IBC with PMLA was not foreseen by the BLRC committee as well. So these two legislations, both legislations are special legislations, and that makes the situation more tricky because if you see few of the landmark Supreme Court judgments, so they say whenever there is a issue with regards to the overlapping jurisdictions of two statutes, so the Supreme Court is always of the view, firstly, that a special legislation should override the general legislation, and if there are two special legislations, then the later one shall prevail. So these are the like very basic interpretations which have been over the period of time given by the Supreme Court. So here in this case, both the legislations are special legislations. PMLA and IBC both are special legislations. So the NCLT, the NCLATs, and the Supreme Court has somewhat right now also has somewhat very differentiated stances on which law must prevail over the other. So going by a simple logic, the clear answer would be the Insolvency and Bankruptcy Code because it is a later legislation. But still, there are lot many issues which are there if the IBC prevails over PMLA. So for that purposes, the overriding clauses of these two legislations are looked into. So for first overriding clause of section 238 of the IBC, and then the overriding clause of PMLA, that is section 71. Now these two overriding clause are very similarly worded, and if we follow section 71, then it is clear that the PMLA has to take precedence. If we follow 238 of IBC, it is very much clear that the IBC has to take precedence. But what is the clear position? Now, some of the courts have opined that okay, the later law prevails, as we were discussing previously as well. But when the objectives of two legislations are distinct, but they are affecting the same set of parties, so how do you resolve that clash? If the IBC is given precedence over the PMLA, then the issue might be that the accused, the person who has been accused of the offense of money laundering, he may very comfortably flee out of the country, because now his assets are under the control of RP. He knows that he is not going to get anything, and when the RP is under control, his company is under control, his company is going to get revived. So he he's more of a opinion that okay, now I may leave the country. But when the PMLA, when the enforcement directorate is on his back, the ED is attaching his properties, attaching his bank accounts. So ED is trying to create a vicious circle to trap that particular accused. But if the IBC is given precedence over PMLA, so that uh, trapping of the accused may not be possible, because then ED won't be having anything in their hands to get hold of that particular accused. So that is why, despite there being overriding clauses on in these two legislations, and despite there being the interpretation, the law settled by the Honorable Supreme Court of India that the later law shall prevail, but when this tricky situation comes up, these two things are also not helping out to resolve the issue that which act should prevail over which. So we take a look at few of the judgments of where the Supreme Court of India has given judicial analysis of the over how to read overriding clause. So when we come to the first judgment, that is the Solidaire India Limited versus Fair Growth Financial Services Limited. So in this case, also the Supreme Court has observed that the latest law, latest special law, shall prevail, and then we come to the Maruti Udyog judgment, which also follows the uh, judgment of the Supreme Court in Solidaire India Limited, and then now these two judgments are the judgments where the a generic position of law has been laid down by the Honorable Supreme Court. So now when we come to the case of Deputy Director, Deputy Director ED Delhi versus Axis Bank. Now this particular judgment was faced in this particular case. The situation was the clash between IBC and PMLA. So here the Delhi High Court interestingly has analyzed the overriding clauses of the SICA, Sikh Industrial Companies Act, of the SARFAESI legislation, of the IBC, and then of the PMLA. Now, when Delhi High Court has delved into the analysis of all these overriding clauses, the Delhi High Court has observed that the PMLA and IBC, these two legislations operate in a very different domain. So when you are comparing when you are applying the analogy that the later law shall prevail, you must be analyzing two legislations which are operating in the same domain. So for example, SICA, SARFAESI and IBC. These three legislations are in line with each other for the fact that they are operating in the same domain, that is the insolvency and bankruptcy laws. However, when we talk about PMLA and IBC, their domain are very different. Therefore, The judgment of the Delhi High Court in this case was not very clear that which statute should take precedence over which statute. And the Delhi High Court has also observed that there should be a narrow interpretation which has to be given to the overriding clauses of these two legislations when these two legislations are in conflict with each other, because the purpose of PMLA is quite distinct from the purpose of the IBC. So therefore, these two, the Delhi High Court in this particular case gave a very narrow interpretation of the overriding clauses, and this they also discussed that if the PMLA is surrendered to IBC, then the purposes of both the legislations would be frustrated, because it will provide a backdoor entry to the corporate debtor who is allegedly involved in the money laundering act. So, moreover, the purpose of PMLA is towards societal interest, and when you are giving precedence over the giving precedence to PMLA over the IBC, then you are hampering the property rights of the creditors. So, how do we solve this position? Is the question before the Delhi High Court, which the Delhi High Court could not also resolve in much better words. So, moving forward, when we come to the judgment of Rajiv Chakrabarti, resolution professional of EIEL versus ED. So, in this case, the just a minute. Yes, so this is also the case by Delhi High Court. So, in this case, the Delhi High Court has improved their interpretation with the support of Section 32A. Now, before going into the judgment, let's take a quick look at what is Section 32A. So, Section 32A of the IBC was inserted by the Amendment Act of 2020, and it was inserted with effect of 28/12/2019. Now, this particular section of the IBC, it simply says, and we just, for the purpose of today's lecture, we'll just read the introductory para, that notwithstanding anything to the contrary contained in this code or any other law for the time being in force, the liability of a corporate debtor for an offence committed prior to the commencement of the CIRP shall cease, and the corporate debtor shall not be prosecuted for such an offence from the date the resolution plan has been approved by the adjudicating authority under Section 31. If the resolution plan results in change in the management or control of the corporate debtor to a person who was not, then there are few conditions. So primarily what does Section 32A talks about is that there will be no criminal liability towards the corporate debtor once the resolution plan has been approved. So this again creates a very, very difficult position for the PM for the purposes of PMLA, because as also discussed in the Rajiv Chakrabarti case, so what the Delhi High Court has done is they analyze the overriding clauses of both the legislations in light of Section 32A, and the Delhi High Court has said that interpreting Section 32A and then reading it with the overriding clauses makes the legislative intent clear, that despite that the legislature was clear that despite there being a Section 238 of the IBC, they felt the need to enact Section 32A to make the position more clear that once a corporate insolvency resolution process is concluded by receiving a proper resolution plan, the CD is absolved of all the criminal liability which was there pre-CIRP up till the acceptance of the resolution plan. So, therefore, the Delhi High Court has observed that as per Section 32A and Section 238, the IBC can override the provisions of the PMLA only when the CIRP is completed and not before. So what this judgment has done, this judgment has, with this interpretation, this judgment has now created three phases. One is pre-CIRP, one is during CIRP, and one is post-CIRP. So Rajiv Chakrabarty's case has cleared the light when it is come when when the stage has come to the post CIRP scenario. So once the CIRP is completed, the CD is absolved of all the criminal liability as per section 32A, and then so in such a case the IBC is having precedence over the provisions of PMLA. Now, still the question is left, what about pre-CIRP and what about during CIRP? So, now after discussing the Rajiv Chakrabarty case, which have clarified the position of post-CIRP cases, we go on to discuss what happens during CIRP. If the clash is there between PMLA and the IBC, when the corporate insolvency resolution process is going on. So during CIRP stage, there is a clash of section 14 and section 14 of IBC, that is moratorium, and section 5 of the PMLA, which is the attachment of property. Now, as we all know that as per section 14 does not uh, bar any criminal action against the CD. And section 14 simply provides a moratorium, better known as a calm period, that there should be no recovery actions against the CD, and there should be no other proceedings, other civil proceedings. But section 14 in its specific terms does not bar any criminal proceedings against the CD. So why should the attachment of property by by the ED under PMLA should be barred when the section 14 in clear terms says that like in clear terms it has laid down the law that criminal proceedings are not covered under section 14. So to resolve this debate, we come to the judgment of yes. So to resolve this debate that why section 5 should not operate uh, when section 14 does not say anything about criminal proceedings. So for this we have somewhat conflicting judicial opinions. So these are Varsana Ispat Limited case. In this case, the NCLAT has simply held that ED simply upheld the powers of ED for attachment of property in pre-CIRP stage. So this case clarified the position that when the ED is initiating any action, uh, when the case is at pre-CIRP stage, so ED is at full discretion to do so, and that also makes sense. Once the CIRP is not initiated, then the company is not under insolvency resolution proceedings. Then why to bar ED from attaching the properties and proceeding under PMLA? Then the Rotomac Global Judgment, they also reaffirmed the stance in the Varsana Ispat case. So the situation, or let's say the dispute, arose with the case of ED versus Manoj Kumar Agarwal. Very good case, landmark case by NCLAT. So in this case, basically the issue was again the tussle between the PMLA and IBC. Now, in this case, going on with our the discussion which we already had, that the objectives of PMLA and IBC, Then the NCLAT also discussed these objectives, and then NCLAT also discusses that Section 14 of the IBC does not bar any criminal actions against the CD. So why not Section 5 should apply during CIRP? So for this, interestingly, NCLAT distinguished the Varsana Ispat case and Rotomac Global also. So what has NCLAT has relied upon a Supreme Court judgment of Parina Swaroop versus Union of India, wherein the Honorable Apex Court has observed that the proceedings carried out under Section 5 and 8 of the PMLA to provisionally attach the property are of civil nature and not of criminal nature. So again, situation was, it was differentiated, and the situation again got intertwined, that now the Supreme Court has come up with a interpretation that Section 5 PMLA proceedings are of civil nature. So if it is of civil nature, then Section 14 moratorium must also apply. So the NCLAT has observed that the Section 5 attachment proceedings, they are civil in nature, and therefore these proceedings are to be halted when Section 14 of the IBC comes into play. Then the NCLAT further observes that, further also lay down the interpretation that the both IBC and PMLA, the special legislation, IBC being a later law, should prevail. So with all that analogy, the NCLAT went on to observe that the IBC will prevail over the provisions of PMLA during CIRP as well, because they, with their distinct stance that Section 5 and 8 provisional attachment proceedings of adjudicating authority under PMLA are civil in nature. So however, now when we have discussed the disputes of attachment of property under PMLA and IBC, and uh, how the stance of different tribunals is with regard to this issue, I would like to take your attention to towards a very interesting case. So this particular case is not about IBC and PMLA. Rather, this particular case is about the clash between Negotiable Instruments Act and the provisions of IBC. So P. Mohanraj versus Shah Brothers Ispat Private Limited. So very interesting case. So in this case, the Honorable Supreme Court of India was faced with an issue that when the Section 14 moratorium is in play, 138 proceedings under the NI Act, are they to be halted or not? Because technically, 138 NI Act proceedings are of criminal nature, and Section 14, as we have also discussed, it does not apply to criminal proceedings. So, interestingly, the Supreme Court in this case, they applied the doctrine of lifting of corporate veil. So, Supreme Court took into consideration Section 141 of the NI Act to say that in the cases of check bounce negotiable 138 Negotiable Instruments Act, so when the offense is committed by a company, it is the management who is to be held responsible, who is to be held guilty in such cases. Therefore, Supreme Court, by analyzing Section 141 of the NI Act, observed that there should be lifting of corporate veil, and 138 proceedings due to the operation of Section 14 IBC cannot operate against the company, but it may operate against the management, because Section 141 of the NI Act makes it clear that when the check bounce offense is committed by a company, it is the management who has to be held responsible. So going by that logic, they said that Section 14 does not affect the 138 negotiable instrument Act's proceeding. And Supreme Court also uh, came down heavily to reiterate the point that the purpose of moratorium is to preserve the estate of the corporate debtor, and the estate of corporate debtor can be preserved by the operation of section 14, but that doesn't mean that you give a blanket protection to the uh, ex-management, to the promoter, to the director of that particular company. You cannot give a blanket protection to a person who has, who has done all these misdeeds, who has pushed the company into insolvency. So, to differentiate between corporate debtor and the persons or the management running the company, the Supreme Court has very beautifully made a analysis of Section 141 NI Act in this judgment, and they observed that 138 negotiable instrument proceedings may go on against the persons, if not against the company. In that manner, the property was also preserved. The persons who are responsible for the offense, they are also, they are also held guilty, or they are also subjected to the trial for which the offense has been committed. So this now, taking this logic from P. Mohan Raj's case, now if we are to apply this logic in the PMLA cases as well, see, when a company goes insolvent, we all know under the IBC, the management is pushed out and the RP comes into control. Now, when a when that similar company is now having there are allegation against that similar company of money laundering. So it is not the company against which the ED is running. It is the persons who are responsible for the actions or affairs of the company. The ED is running behind those persons to get hold of those persons. So when there is a clash of IBC and PMLA, so why not a division as reflected in P. Mohan Raj case can be done in this manner, that the property is given to the RP. However, ED is free to uh, you know get hold of the persons responsible for money laundering, and hold uh, catch hold of those persons, put them to fair trial, and then let their fate decide that whether they are guilty or not. And ultimately, the goals of the two legislations, if we see in the PMLA as well as the IBC, ultimately the goal is to stabilize the economy. So stabilization of economy can be done better if the property is given to the RP, and then RP, with the commercial wisdom of COC, takes a decision of resolving the entity or liquidating the entity and using that property in those proceedings so as to maximize the value given to the creditors as well as for the corporate debtor. So this is something which can be done when there is a clash between IBC and PMLA as well. Now, discussing about Section 32A, so much known principle of clean slate, that Section 32A protects resolution applicants from prosecution after CIRP. So the wording of Section 32A is a bit tricky. So the first, I'll just give you two case laws where the constitutional validity of the Amendment Act of 2020 was upheld, and 32A was observed to be a good law. Now, coming to the a bit confusions which this section 32A has created. Now, when we read the language of this section 32A, sorry, yes. So when we read the language of section 32A, so it is given that the liability of a corporate debtor for an offence committed prior to the commencement of the CIRP shall cease. However, we have to read this along with the subclause A, B, C to subclause A, B and the provisos in subsection 2. Then only it will make sense and we can understand the purpose of section 32A better. So I just start from here. If the resolution plan results in the change in the management or control of the corporate debtor to a person who was not a promoter or in the management or control of the corporate debtor or a related party of such person, or a person with regard to whom the relevant investigating authority has on the basis of material in its possession reason to believe that he had abetted or conspired for the commission of the offence and has submitted or filed a report or a complaint to the relevant statutory authority or court. So just with this line also you get the clarity. The liability of a corporate debtor for an offence committed prior to the commencement of CIRP shall cease, and the corporate debtor shall not be prosecuted for such an offence from the date of the resolution plan has been approved by the adjudicating authority under section 31 if the resolution plan results in the change in the management or control of the corporate debtor. So here section 32A is not protecting the ex-management. It is protecting the resolution applicant who is now coming into the picture. Corporate debtor does not mean the promoter of the company or the director of the company who was previously there. The corporate debtor only means the company. And specifically when this section reads that if the resolution plan results in the change in the management or control of the corporate debtor, then only the liability of a corporate debtor for an offence committed prior to the commencement of CIRP shall cease. So there has to be a change in the management or control of the corporate debtor. Then only section 32A will have the applicability. Then only section 32A will safeguard the particular corporate debtor from the prior offences which have been committed. So it is not safeguarding the ex-management, it is not safeguarding the ex-promoters, it is safeguarding the successful resolution applicant. And the successful resolution applicant is getting that company from a clean slate so that he can now, without looking back, he can now look forward and carry forward the operations. So sometimes this section 32A is confused that the section 32A is giving protection, undue protection to the uh, ex-management, but that is not the case. That is why even in the case of Manish Kumar versus Union of India, then again Shiv Charan versus Adjudicating Authority, both these case in both these cases upheld the validity of section 32A. Now this we have already discussed. So when we come to the conclusion of our discussion. So after discussing what the purpose of IBC, the purpose of PMLA, the issues which are being, which are being raised before the tribunals, before the Supreme Court, between the tussle between the IBC and PMLA. So we come to the point that the firstly the purpose of both the legislation is towards protecting national interest and as well as economic stability. When we talk about national security and national interest, PMLA talks about it specifically, and when we talk about economic stability, IBC talks about it specifically. But indirectly, PMLA is also a legislation which contributes towards the economic stability, and IBC is also a legislation which contributes towards the national security. So streamlining of these two laws is quite urgent because there have been now lot many cases, and there are lot many cases coming before the Honorable Supreme Court, High Courts of different states, NCLTs and adjudicating authorities of under PMLA, where these two legislations are clashed with each other, and the most as per me the affected the parties due to this tussle is the ED and the RP, because these two have to run to one court to the another, whether to get release of the property, or whether to get some sort of permission from this court to proceed against corporate debtor. So a detailed discussion is required from the side of the legislature, and then amending these two legislation is the need of the hour. And lastly, uh, to address the immediate concerns, I think the regulators, the IBBI, can come up with a few regulations, or in the meanwhile they can issue circulars which may clarify the position a bit, which may distinctly define what is the role of ED, what is the role of the RP when these two legislations come and clash with each other. So in such a eventuality, how should the proceedings go forward? So I think in the meanwhile, the regulators can play a very important role. Now, as we have also discussed the P. Mohan Raj case, we have also seen the clash between the provisions of NI Act and the IBC, and that was very, you know, uh, it was a very good judgment that resolved that issue, and that similar analogy can also be adopted to resolve the issues in the PMLA and IBC cases. So this is how the IBC is somewhat, you know, uh, what do you say, is clashing with the other laws that are now in place. So even when we talk about the, some other laws, for example, we take SURFACE also. So SURFACE has not been repealed; it is being there and it is being followed as well. So SURFACE, being a purely debt recovery law, is now somewhat like, if there is a clash between IBC and SURFACE, it is the law is very clear, IBC will prevail. But interestingly, the situation is now such after the 9 years of IBC, financial creditors, which are the banks, they are more inclined towards initiating SURFACE proceedings and more inclined towards, you know, uh, going with the SURFACE route than IBC, because now there are so many cases of IBC in the NCLTs, and the institutional infrastructure is not so efficient or effective in resolving these cases. So the financial creditors are now again taking the route of SURFACE and proceeding towards the debt recovery. So these are few things which are now coming up with the IBC, and I think this PMLA and IBC issue will take time, but it needs to be resolved urgently. So I think that's it for today. So uh, we can conclude the class. Thank you, everyone. Thank you so much.